Okay, we're on the record this morning in People versus Stampfly. This is case number 235220. If I could have counsel put your appearances on.
Here, on behalf of the people.
Your Honor, my name is Craig Lockhart. I'm here today on behalf of Mr. Stampfly. Mr. Stampfly is standing next to me to the left.
The date time set for sentencing in this matter. Mr. Stampfly, have you had a chance to go through the pre-sentence report and talk to Mr. Elhart about that?
Yes, sir.
Oh. Mr. Elhart, are there any additions, deletions, or corrections that you made?
There are not, Your Honor. We find it accurate.
Any challenges to the scoring?
No, Your Honor.
Ms. Pope, does the have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Do you have any victims that wish to address the court today?
We contacted them. They did not respond.
Anything on behalf of the people for Alex?
I don't have a lot to say. The court sat through the trial, saw the video, heard from the child that witnessed this. Mr. Stampfly has lived, an otherwise exemplary life up to here. He has 0 felonies, 0 misdemeanors, and no juvenile record. I think what he did in this case was pretty egregious. I think a lot of it probably had to do with his own medical issues. Maybe he didn't understand the threat or the lack of threat in this case. I have dogs. Many people in this community have dogs, and I think it's awful that somebody would shoot somebody's dog, especially when there was no threat to them at all. I think the court should punish the defendant accordingly. Thank you.
Your Honor, I first took this case, so obviously I've been practicing law for so crimes to animals are, in my mind, judged more crimes to human beings. Mr. Stampfly was convicted. He thought he was doing the right thing in his mind. He thought he was at risk. He's been in the neighborhood a long time. Nevertheless, he's been convicted and understands that he is having exemplary life. His prosecutor has indicated, and I believe there's some jail time. I think court recommendations.
Thank you, Mr. Stampfly. Was there anything you wanted to say today?
No, sir.
I did read through the report. Obviously, I presided over the trial, so I'm familiar with the facts and the evidence that was produced during the trial. I heard your testimony. There's also information in that report about you and your background. And I think this is a case where there are a lot of different competing factors. In your favor, what I would consider mitigating factors. You're 57 years old. You don't have any criminal history. You haven't been involved in the criminal justice system at all, which tells me that you've lived a law-abiding life. You've done generally what you're supposed to do, and that gives the court every indication that outside of this incident, you would continue to do that and not have further contacts with law enforcement. There are some negative factors here, and there's really 3 of them that I can see. First of all, it's apparent to me from the video that at the time that you shot the dog, that the dog really wasn't presenting any kind of threat to you at all. It was running back to its owner, and you make the decision at that point to fire your weapon. Everybody at some point in their life has been in a situation, sometimes when they have neighbors who have dogs, where those dogs get out, they're not properly restrained by a leash or whatever it may be. That's just one of those things that kind of happens in life, and you have to know how to deal with it correctly. I get being frustrated with it too. We've all had neighbors with dogs that are frustrating. I'm a runner. I have dogs come out at me all the time when I'm running along the road. It's frustrating. But I'm not going to carry a gun and shoot the dog because it does that. And I think clearly in this situation, your actions were unwarranted. So that's one concern. The second concern is there were kids around. Discharging a firearm, killing a dog in front of a child, I think shows a lack of good judgment. And discharging a firearm in a neighborhood also shows a lack of good judgment with regard to firearms generally. This wasn't a situation where, you lived in a house out in the country where there's nobody around. This was a populated area. There were people close by, relatively at the time that you discharged this firearm. And again, I just think that shows really poor judgment on your behalf. So regardless of whatever justification you thought you had in your own mind, it wasn't a good idea to use that weapon in that way in that location at the time you did it. All of that being said, in terms of an appropriate penalty here, I think probation is an appropriate sanction along with monetary costs and fines rather than jail time. The court has two different ways that it can punish wrongful conduct. You can have your freedom taken away and be incarcerated, or you can be punished by being supervised for a period of time subject to conditions and ordered to pay fines and costs. And I think that's an appropriate sanction given your lack of any prior history. I also think that an appropriate condition of probation is that you not be allowed to possess any weapons, because again, I think your actions here give the court some concern about your judgment and proper exercise of discretion. If you do have weapons, that's the way you use those. So the court is going to follow the recommendation. You are going to be placed on probation for a period of 18 months. The court is going to adopt all the conditions of that probation. The court is going to add a condition in that you not use or possess any weapons. Of course, because of this conviction, it's a felony, you're not allowed to possess any firearms going forward in and of itself, but the court is also going to add a condition that you not possess any other types of weapons. The court is going to order that you serve 1 day in the Crawford County Jail with credit for 1 day served. Crime victims assessment of $130. Supervision fee of $30 per month while you're on probation. A DNA testing fee of $60, $68 state cost, and a crime, I didn't say it already, a crime victims assessment of $130.
Your Honor, apparently I also missed the court cost of $325.
Okay. And court cost of $325. You do have the ability to seek an appeal of this sentence. Mr. Elhart, I think table next to you. You don't already have it, Mr. Sample right. Spoke anything further on this case today?
No, thank you.
Okay, Mr. Sample, just make sure you meet with Mr. David before you leave today to go over your probation.
Yeah, Coach.
Yes. People versus Kyle Bertel, case number 245300.
Sierra Coke on behalf of the people.
I think you're right for this.
Thank you. This is set for a status conference today, Mr. Chairman.
Yes, Judge, I would ask for a short adjournment of this matter. There's a preliminary exam that was held in this matter. The transcripts, I don't have those yet. I know there's a co-defendant's case that also just got filed over. So I can go forward. There might be a motion from the people for consolidation that might come through. That case is set for 10:30, so I think if that happens in the future, we just set them in close proximity, so Mr. Thompson can also be here at the same time with the two cases. I don't know if he's ordered the transcripts yet, because we were waiting on a written opinion of that matter from Judge Burmeister. So I know that just came through.
That's the bind over.
That's the bind over on Ms. Bradley's case.
Okay.
And then I've got two other things that I have to on mind accomplish. There's a handwritten letter in Mr. Patil's case that was admitted as evidence in district court preliminary exam, seeking a handwriting expert to analyze those letters. So I've secured a handwriting expert. We just need to get the documents to him and so on. and then a forensic analysis of the phone.
Okay.
So there are just some moving parts that we need to work through. So I would ask for an adjournment. I don't know what's going to be, right, 30 days, 60-day adjournment. These things just take a little time. And there's a issue of the transcriptionist. I did send it to one transcriptionist who sent me an email back saying she couldn't get it done in a timely manner, so we sent it to somebody else. So we're working through that issue as well.
Okay. In terms of the ultimate resolution in this case, are you anticipating going to trial?
At this point, we are subject to the forensic analysis of the phone and the handwriting. I think that changes a couple of things depending on how those come back and so on.
All right. Let's go.
I'm not sure which phone they're doing the analysis on. We don't have the victim's phone to do that on. The mother destroyed the phone. But I do know that he's asking for these things. He needs the time to do them, so I don't object to a short adjournment. I will be doing a motion to consolidate if both cases are wanting to go to jury trial. which-
Well, here's what I'm thinking. If the other case is bound over, are you gonna be asking that these consolidated?
Yes, if they are going to trial, it just got bound over. It's up today at
10:30.
10:30.
I'm just wondering, and maybe counsel, give me your opinion on this. If we get this on the trial track at trial dates and then, say, like, set trial dates for 6 months out and then build in some cutoff dates within that period of time.
Oh, I think that'll be fine.
That would be fine, Your Honor.
Yeah, I think that'll be fine.
Okay.
And then I would just ask that to apply if, to Ms. Bradley's case, they're going to consolidate and so on,
Okay.
keep them on the same track and so on, that would be fine. Again, I don't want to speak for Mr. Thompson, but I think,
So let's do this. Well, let's say if these are tried together, how many days of trial?
I mean, it depends on if defense is calling witnesses. If not, I think I can do it in one day. If they're calling witnesses, we'd ask for 2 days.
I don't wait 2 days, there are some defense witnesses we'd like to call, and there might be an expert that'll, again, with the handwriting expert, that could be an issue. 2 days.
Okay, so, and I'll discuss this with Mr. Thompson, but my anticipation would be the court would set both of these cases for trial about 180 days out. I'm gonna set aside 3 days for trial. This afternoon or later this morning, I'll let Mr. Thompson know, but I'll just ask Jennifer to stack these two together on the same date, so if they're consolidated, you already get dates for both, if they're not, adjust it. And then if we set motion cutoffs at 90 or 120 days. What do you guys think? How much time do you think you're gonna need to get?
I would say,
And that would just be cut off. I mean, you can file motions at any time, but that would just be.
I would say 90 days.
I think 90 is fine, if there's an issue, we can of course motion the court.
We'll do a motion cutoff at 90 days and then the court will set this for a final status conference. Like we normally do prior to trial, and that'll be the plea cutoff, so we'll give them a little extra time for pleas there. Mr. Gilmurphy, any other dates that we can set for your side of this case today?
Not today, Judge, I think we'll send it.
So,
No, thank you. We'll get that motion filed in the next couple weeks so that we can have that issue resolved early.
Mr. Bertel, do you have any questions about how we're gonna go forward in your case?
No, Your Honor.
Okay, all right, thank you. That's all for today.
Thank you.
Okay, next hearing is 9:45, so we'll take recess. Mr. Fragel.
He said he wasn't really sure if Mr. Frego was going to appear.
That's probably Mr. Ashton. I did get a request for Mr. Fragel to appear by Zoom today.
Oh, good.
Here, Anthony,
Yes.
have you spoken to Mr. Fragel yet today?
No.
I'm gonna take a short break and see if kind of contact his office, find out why he's not signed in, so let's just take a minute. we'll go on the record in People versus Tony, case number 225130. The record should reflect Mr. Tony is present here today. We have the prosecutor present here in the courtroom as well. Mr. Tony's attorney, Mr. Fragel, had asked the court to appear by Zoom today, which the court did grant that request. Set for 9:45. It's now almost 10. He has not appeared. Mr. Tony, you understand that you have the right to a lawyer present today?
Yes.
Okay. And is it your request to proceed without Mr. Fragel present?
Yes.
Okay. Mr. Tony, we're here today following up on a previous hearing that we had in which you were sentenced to participate in the sobriety court program. The information that I have indicates that you successfully completed that program and otherwise have fully complied with all the orders of the court during interim. Ms. Cope, did you receive that report as well?
I did.
Ms. Cope, do the people take any position on how the court should proceed?
I'm really glad that Mr. Iatoni got into sobriety court. I think he might actually be one of the last ones that we were able to get into sobriety court because of all the rules that changed. So it was very lucky that he got in. I heard him talking before the court hearing to the bailiff. He sounds like he's doing very well. He has very minimal criminal history besides his drunk drivings, which are old, one in 1997 and one in 2014. I'm glad to hear he's successful. We don't have very many successful people that go through it. It's a hard program, and I hope that I don't see him again. I don't think I will.
Thank you, Mr. Tony. Anything you wanted to say?
No.
Well, I agree with what the prosecutor said. I would echo her comments. I would also say that something that you should be proud of yourself greatly for accomplishing. It's not an easy program. I presided over sobriety court for a number of years, and I know that it's rigorous. I know the requirements really keep you on your toes. And so your successful completion indicates to me, number one, that you have a really good chance of moving forward without reoffending, which is the whole purpose behind the program. And number two, it indicates to me that this is something that you wanted to do for yourself, so that not only do not have further involvement in the criminal justice system, but just so that you live a better, more productive life. Because I don't think people get through that program unless they really do want to do it for themselves, not because they're being made to do it.
Right.
So anyway, I want to congratulate you on completing that. It is, I think, an important accomplishment. And so that's all I really have in terms of paperwork to resolve this for good. The court will order that your conviction to the OWI third be withdrawn, and that conviction as to OWI second be entered. Ms. Cope, do you agree that that was the terms of the agreement in this case?
It is.
The court will also include 1 day of jail with credit for 1 day served, and successfully discharge you from probation. Mr. McDowell, is there anything that Mr. Tony has to do to follow up with you?
No, I'll get once his discharge is done and signed, I'll put him in the mail to him.
Okay, thank you. Mr. Tony, do you have any questions?
No, sir.
Okay, all right, thank you.
Thank you. Appreciate it. All right, take care. Thank you.
There's Richard.
Mr. Trush, are you able to hear me?
Yes, Your Honor.
All right, is that Mr. Ashton? That person just signed in under a device name. I don't have an actual name. Have you met him before?
Mr. Ashton, is that you?
And Mr., if that is him, Mr. whoever you are, you need to connect your audio, please, to your Zoom app. Otherwise, we're not going to be able to hear you.
And Your Honor, I do believe that is Mr. Ashton.
Okay, thank you. While he's attempting to do that, we'll go on the record in People versus Ashton, case number 245305. The record should reflect that both Mr. Trush and Mr. Ashton are appearing today by Zoom by prior approval of the court. We have Ms. Koch present here in the courtroom today. Again, while he's attempting to do that, Mr. Trush, can you tell me where this file is at right now?
Thank you, Your Honor. Yes, I do believe we have a resolution for the court whereby Mr. Ashton would plead to an added count of use of a controlled substance, and the principal charges, I believe, would be dismissed.
Okay, and what is the maximum possible penalty for the added count 3?
It is 1 year and or $1,000.
All right, Mr. Ashton, now we need you to unmute, please.
Yes, sir.
Okay, great. Mr. Ashton, were you able to hear what your attorney said there?
I did not. I just got, this is my wife's phone. I just got the audio to work. I apologize.
All right, Mr. Trush, if you wanted to restate that for the record, please.
Yes, Your Honor, thank you. So we do have a resolution for the court today whereby Mr. Ashton would be pleading guilty to use of a controlled substance. That's a 1 year offense, maximum penalty of 1 year and or a fine of up to $1,000. And in exchange for that, the 2 principal felony counts would be dismissed.
That is the correct statement of the offer, and the PAC code is 333.74042B.
All right, Mr. Ashton, were you able to hear that?
Yes, sir.
Is that how you want to proceed today?
Yes, sir.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Mr. Ashton, are you currently on any kind of probation or parole?
No, sir.
And you understand that the maximum possible penalty that you could face for use of a controlled substance is up to 1 year and or a $1,000 fine?
Yes, sir.
With that penalty in mind, what is your plea to that charge today?
I plead,
Okay, you're breaking up a little bit. Can you say that again?
I plead guilty, Your Honor.
Okay, thank you. I'm gonna go through your rights with you. And if at any point your audio cuts out or you need me to repeat any of this, please let me know, all right?
I will. Thank you.
Okay, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
I do.
And do you understand that you're giving up and waiving all of those rights by pleading guilty?
I do.
Has anybody threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here on the record today?
No.
Is it your own free choice to plead guilty?
Yes.
And are you pleading guilty because you are guilty?
Yes, sir.
The information I have indicates that this took place on April 3rd of this year. Is that the correct date?
Yes, sir.
On that date, were you present here in Crawford County?
Yes, sir.
And on that date, while you were here in Crawford County, did you use some methamphetamine?
Yes, sir.
Did you have any legal right to do that at the time?
No, sir.
Right. Ms. Koch, are you satisfied with the factual basis?
Yes.
Mr. Trush, are you satisfied with the factual basis?
Yes, Your Honor, I am.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No.
Mr. Trush?
I'm aware of none, Your Honor.
Ms. Koch, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes.
Mr. Trush?
Yes.
Mr. Ashton, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this added charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. Mr. McFella, how do you want to get in touch with Mr. Ashton?
If he could provide I know he says he's using a different phone, but if he could provide a phone number that I could reach to him today.
Mr. Ashton, we need you to give us a phone number where the probation officer can give you a call, okay?
Sure. Right now it's 443-978-9705.
Okay, so Mr. Ashton, somebody from the probation department is going to be giving you a call at that number. It's important that you follow up with that call when you get that, okay?
Absolutely. Thank you.
All right, Mr. Trush, anything else we need to address from your side today?
No, thank you, Your Honor.
Ms. Koch?
No, thank you, Your Honor.
Okay, Mr. Ashton, that's all for the hearing today. You're free to disconnect at this time, and you as well, Mr. Trush.
Thank you very much.
Mr. Thompson, I know we're early, but are you ready on Ms. Bradley's case? I don't believe Ms. Bradley's here. Oh.
He was with
Okay.
Patel.
Right.
Okay, we're on the record now in People versus Alexis Bradley. This is case number 245301. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Madam. Jason Thompson on behalf of defendant Alexis Bradley.
Okay, Mr. Thompson, this is set for a scheduling hearing today. How do you want to proceed?
I know the court has a scheduling hearing with the co-defendant today or in the related case. I will be looking to file a motion within the next 30 days to quash the bind over. I believe I think I have the transcript back. So I think that should be able to be filed. I think we could put this on a parallel discovery track of all motions within 90 days, a trial in approximately 6 months. This will require a little bit more investigation than an average case.
Ms. Koch, we kind of already touched on this previously this morning. Do you have any objection to that?
No, but if he does have the transcript, I'd ask him to give it to Mr. Grimwood, who indicated he could not get it for 60 days. So if they could just touch base on that issue.
Okay. Okay, so the court is going to set this for a 3-day jury trial about 6 months out. court's gonna stack it with the co-defendant's trial, Mr. Berthold. If cases are consolidated, we can track together at that time. Not that schedule a different trial date. The court will set a motion cutoff at 90 days, and then it'll set the case for a final status conference prior to trial, which will be the plea cutoff. Any objection to that, Mr. Thompson?
No, Your Honor, I guess I don't have the transcript yet, but I do, believe it'll be in shortly. I don't have any objection to the other provisions. We'll figure out whether it's some consolidated trial, after some further investigation.
You can also address for yourself.
Your Honor, just has the bottom be continued. Your mailing address.
Ms. Koch, anything further?
No, thank you.
Anything further from your?
No.
Okay, all right, thank you. That's all for this hearing.
All right, thank you, Your Honor. Yes. Yes.
We're on the record. I'm gonna call the case of People versus Travis Ackerman, case number 235232 of council with your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Travis Ackerman.
Okay, so this was set for a final status conference at 10:30. We currently have a trial date in this file on June 10th. I understand, I've gotten some information from the clerk's office this morning about Mr. Ackerman. I think we should probably make a record. I don't know who wants to do that.
I will, Your Honor. I spoke to Detective Clapadlo. He is with Mr. Ackerman. He was pulled over on a traffic stop. They just got to the ER. He had methamphetamine on him at the time. They expect more charges to be coming. He did not appear for court on Tuesday on his other newest meth cases. He is definitely struggling right now, and I don't know that he's going to be in any position to go to trial on Monday. Normally, as the court knows, I push hard to have our dates go. I don't ask for adjournments, but I'm not sure that there's any way Mr. Thompson can be ready for trial with a client that's just not able to communicate with them.
And Your Honor, I want to make the same record. Last, I'd say 2 months, Mr. Ackerman has been struggling. It has interfered with my trial preparation. I haven't requested an adjournment yet because I don't want to sort of let him off the hook or reward him. But at this point, I anticipate he'll be in custody, so I don't think he's going to be avoiding any kind of sanction or delaying any kind of sentencing. I would anticipate that the now 3 cases would result in a global resolution. I was really hoping he'd show up today so we could try to put a global resolution on. I think this is a case where prudence would suggest an adjournment, and I don't think anyone's going to look at this situation and say that he got any benefit from this. I anticipate he's going to be held on these bench warrants. I don't anticipate he's going to be out. So I don't think there's any benefit that's going to go to him. But I'm not ready for trial. I've been trying to get him to turn himself in and address that. I certainly have been addressing expert witnesses and testimony. He's not been in that position with me, Your Honor.
And his bond is revoked right now in this case.
Okay. All right. Has he been, so he hasn't been arraigned on the district court file yet because he didn't appear earlier this week, is that right?
No, he was arraigned
Okay.
on the second case. He was arraigned and a fairly low bond was set, but he did not appear at his first court hearing. So there's now a bench warrant in that case.
Okay.
Or actually, the bench warrant may have first arisen from failing a drug test. So then if there's charges today, he hasn't been arraigned on those, obviously. So I believe this court for his non-appearance today could ensure his future appearance. And I would anticipate we would have a global resolution. It's really the only thing that makes sense at this point.
I'm just trying to think of the timing of when his current district court case and potential charges from today might be bound over to this court so that I could set those cases and this one all together for status conference. So like 60 days.
I would say 45 probably even.
Yeah, well, I know that the district judge, district court, there's a couple not open days coming up, right? So it's Tuesday and then it jumps to July, I think. So that would put us at,
All right, I'm gonna set it for
60.
60.
I think given the district court schedule, 60 makes sense.
And then Ms. Cope, I'm gonna ask your office to, well, actually, I mean, I'm gonna issue an order today revoking Mr. Ackerman's bond based on his failure to appear here for today.
I think there was one entered by this court on 521, but that was for something different. So I don't know if we have to do a second one or not.
Yeah, I'm gonna do one based on the failure to appear today. That'll address this file. We'll set all files that are bound over for hearing 60 days together and then see where we're at. Any objections to that, Mr. Thompson?
No, Your Honor, and once he's in, I mean, I may well come back to this court. I mean, my I hope that what I've been working on for some time with Mr. Ackerman is trying to get him into rehab, and I hope I can still do that. I think that's what he's doing in his life right now.
Yeah, I mean, if there are matters that arise between now and that date. Ms. Coe, do you have an objection to that?
No, thank you.
And then the court will of course adjourn by stipulation of parties to the trial date. Correct, Senator?
Yes, no objections, so no attribution. I stipulate.
All right, thank you. Next case, are you ready on Mr. Holland's case?
I am, thank you.
Versus Holland, case number 245302. Present here in the courtroom today. Take time for that. Yes, yes, I have. Thompson, I'm sorry.
No problem, Your Honor. Yes, I did go through this with Mr. Holland. We had no correct position variations or letters. Doesn't necessarily need to get that.
I did receive a letter for. I did have a chance to review that prior to today. Mr. Holland, did you have an adequate opportunity to go through that report and talk to Mr. Thompson?
Yes, sir.
Okay. Ms. Coe, do the people have any additions, deletions, or corrections?
No,
Scoring.
no.
Anything on behalf of people for allocation?
Yeah, I'm sad that Mr. Holland is back here today. Dealt with him a lot over the last few years. I think he got 18 months on his last series of cases. I can't remember how many there was, but there's a lot, four or five of them. We were dealing with him pretty regularly. He got out, he was doing well. I got good reports, heard he was doing good. And then things just went downhill really fast. His guidelines are 10 to 28, recommendation is 24 months. He had only been out on parole for 7 months. And I think that's really the only option, unfortunately. So I'd ask the court to follow the recommendation.
Thank you, Mr. Thompson.
I would generally agree with some of the prosecutor's comments. Unfortunately, Mr. Holland has been struggling with substance abuse. Guidelines are 10 to 28. Understands he's going to receive a sanction here today. He understands that he's here to take that. He's not here to offer excuses to the court. I do think it's important for the court to know that Mr. Holland was in a long marriage, and his wife passed away. And I felt a lot of people in that circumstance, and most people don't handle it well. Most people struggle. Anybody who struggled, he struggled. The way he struggled, unfortunately, he relapsed. I understand what happened in terms. I mean, I understand that he felt terrible and that he relapsed, and I think the court could consider that in terms of how he relapsed. He was doing very well until then. He had passed a drug test something like 8 days before he got caught here relapsing. It's probably good for Mr. Holland. He got caught when he did. So he relapsed and potentially harm him. He was in a really vulnerable place. He made a really bad mistake. He's going to take the sanction for this. But I would ask the court to temper the sanction based on that circumstance in his life and where he was when he relapsed. So I would ask the court to consider a sentence probably 15 or 20 months. But Mr. Holland understands that he's going to be sanctioned, and he accepts that. He's looking forward to moving forward in his life and trying to handle most of the substance abuse and his grief now that unfortunately his wife has passed away. Thank you.
Mr. Holland, anything you wanted to say today?
No, sir, just that I take full responsibility for my actions. I'm not making no excuses for anything.
I did read through the report. I read your sister's letter. It was very heartfelt. It's clear that she cares for you and wants that.
She's the only family that I got now. I'm sorry, but once my wife passed away, all her family disowned me.
Yeah. That's unfortunate. That's the deaths that you had to deal with recently. And I agree, on a personal level, you can understand somebody relapsing, particularly with the history you have, battling addiction, when you're faced with difficulties like that. So I think we can all understand why this happened. It's unfortunate that it did, because given your past history, any kind of slip ups that you have are going to result in time, and you're on parole, which further complicates it for you in terms of what the sanction is going to be. And from my understanding, and Mr. Haven, correct me if I'm wrong in reading the report, but it sounded to me almost like a jail sentence was going to result in a worse outcome in terms of this parole violation.
Because if he receives a jail sentence, the parole violation will go through. And it depends on, the violation specialist, whether or not he would be returned on the violation or defer to the court. It could be a wide range of things. If he is sentenced to prison, the violation will essentially be dismissed.
Right. And any violation
Would be, this sentence would be consecutive to the parole violation.
So, I mean, I'm mentioning that because I'm trying to figure out, and looking at how to deal with this, what the best way to get you out on some supervision in the shortest amount of time so that you take advantage of some counseling, whether that's grief counseling, addiction counseling, treatment, whatever it is,
I've never had a chance to go to rehab. That's one thing I've tried to ask for in the past, and I'm sorry, but you have denied it. So,
yeah. So, in my view, the best remedy for you in terms of getting help is going to issue a prison sentence in this case, because it's
I was expecting it, sir.
it's going to be, it's going to help you avoid having a consecutive penalty with a parole violation. It's within the guidelines. Your case it's so clear to me that this is all driven by substance abuse. Your past convictions, like this totally indicated, all of those that you racked up in that short period of time, you were just doing things that didn't make any sense to a rational person who was sober, and all those things. You continued to drive and have not weapons on you, and all of the stuff that you knew. Everybody knew that what car you were driving, and it just racked up all of those charges. And to me, that is just a clear indication of somebody who's out of control in terms of substance use. So all of those things considered, again, I think an appropriate sentence is one that's within the guidelines, that is a prison sentence, so that the parole violation isn't going to be a consecutive issue. So the court is going to sentence you to 20 months, 10 years in the Michigan Department of Corrections. The court, because you were on parole, there is no jail credit. The court is going to assess $130 in crime victims assessment. Court costs of $325, attorney fees of $300. You have the ability to seek an appeal of this sentence.
I'm not gonna fill it.
I'm not gonna go. Still,
That's fine, but we need to
still acknowledge that you received the notice.
Where's that?
Your signature. And you take 2 copies with you, whether you want to file or not, it's your decision, but you want to have these 2. Let's take
Mr. Church is connecting, so just get that. All right, Mr. Church, are you able to hear me okay?
Yes, Your Honor, I can.
Okay, we're on the record in People versus Carrie Ford, case number 225139. Record should reflect Ms. Ford is present here in the courtroom today. Mr. Trush is present on her behalf by video, and Ms. Koch is present here in the courtroom on behalf of the people. This is set for sentencing today on a probation violation. And Mr. Trush, did you have a chance to go through the violation report with Ms. Ford?
I did.
Okay, and monitor problem solved so that I can see. Ms. Ford, did you have adequate opportunity to go through this report and talk to Mr. Trush about it?
I did, Your Honor.
Mr. Trush, are there any corrections that need to be made to that report?
No, Your Honor.
Okay. And Mr. McFelder or Ms. Koch, any corrections that need to be made?
No, Your Honor.
No, Judge.
Ms. Koch, anything by way of allocution today?
All right, the court can see from the probation report that Ms. Ford just did not do well on probation. The recommendation is 10 months in jail with 113 days credit, unsuccessful discharge. I think that's appropriate. I ask the court to follow the recommendation. Thank you.
Thank you. Mr. Trush, anything on behalf of Ms. Ford today?
Yes, Your Honor. I think there's a couple things that are important for the court to look at in regards to this file. So the first thing is I want the court to understand the circumstances surrounding the discharge from the rehab facility. So the circumstances here were that there was an issue that was brought up in a group session. And not to mince words, basically during a group session, somebody brought up the idea that someone who's an alcoholic could go on to have a few drinks, right? To drink as a non-alcoholic or normal person would. Subsequent to that, Ms. Ford was asking questions about that idea, which is a technical violation of the rehab policy of not discussing anything from group settings. So that's the circumstances that lead to her getting discharged from the rehab. I think that's important for the court to understand because, frankly, outside of that, I think she is ready and she was willing to do the rehab. She's in a position in her life where, frankly, she needs rehab. It would be a huge help to her in struggling with her addiction problem. And frankly, she's discharged for what's the most technical of technical reasons. It's not as if she was using, it's not as if even sort of the classic technical reason of fraternizing. And I think it's a legitimate question that she was raising about that idea. Once she's discharged, she's understandably frustrated. She does know what the right course of action for her to make is. She should have contacted me. She should have contacted Mike McFalda. And frankly, we're probably in a dramatically different situation if she does that at that time. I do think it's important for the court to understand in a lot of ways, I think Ms. Ford's addiction is basically as true self-medicating as it can be. From my getting to know her over the past 2 years, it's clear that she's mourning the loss of her family, the deterioration of her relationship with Big Kenny, as well as the struggles in her relationship with Little Kenny, which is sort of ultimately led to an NA case and ultimately led to the termination of her parental rights. My sincere hope is that Ms. Ford does address the substance abuse issue that she has. I think in order for her to do that, she's going to have to find a way to put herself and put herself ahead of other people, in the sense of she has a tendency to take care of other people before herself. I would suggest that 10 months is probably a little more than the court needs to do. That's essentially the top end of her guidelines. I would suggest to the court a sentence closer to 6 months is probably more appropriate, and would suggest to the court that crafting this in a way that gives her an opportunity to attempt treatment is likely appropriate as well. Thank you.
Thank you. Ms. Ford, anything that you wanted to say today?
Your Honor, I would just like to, first of all, apologize for for not making the right choice of coming back, coming back to jail. And I've realized obviously that it was a very bad decision. I did feel defeated. I felt I was taking it very seriously. I was almost ready to present my first step to the group, and I just kind of feel like I was really let down by the rehab, and it's no excuse for the choices I made afterward, but I'm just really ready to just make the next right choice and just have my life back, I guess. So.
All right, I did read through the report regarding the violation. In this case, although it wasn't your first violation when you were on probation, you had multiple violations. This is just the last one that's finally brought everything to a head here. I had a chance to review the file as well prior to the hearing today. I don't know what happened at rehab. I just know that you were discharged from there. I understand the factual representations that have been made today, but I don't have anything from the rehab that says that's why you were removed. And maybe it was. You certainly should have followed instructions and reported back to the jail. But it's not like that's the only reason why you were here. You had violations before. You tested positive numerous times. You were continuing to use while you were on probation. So it's not like you had one technical mess up and all of a sudden here you are. This is, like I said, the last of numerous attempts to get you to comply, and you just didn't. For whatever reason, you weren't ready to do that. And so when people don't comply with probation, then they have to face the consequences for that. And in this case, I think the recommendation is appropriate. I think it accounts for your failures on probation, and it's within the guidelines of your original charges. So the court is going to sentence you to 10 months in the Crawford County Jail. You have credit for 113 days served. The court is going to order that you're discharged unsuccessfully from your probation. Court will preserve all fines and costs that remain, which is, I believe, all of them. And again, will be discharged unsuccessfully from your probation. You do have the ability to appeal this sentence, and I suppose you have those appellate rights with this board since Mr. Cruz. Ms. Ford, these papers are going to explain to you what your rights are on appeal, as well as how to request a court appointment.
You sign here and date. It doesn't mean to do anything, it's just that you receive them, okay? And it's 6 days.
Mr. Truce, while we're doing that, is there anything further that you needed to address for the record today?
Not for the record today, thank you.
There's court files and we'll be signing and give it to them, okay?
For your argument, the county. Mr. Truce, you're free to disconnect. People versus Shell's case number 992. Well, you and Mr. Shell's on the table there. I can have counsel for your appearances.
Eric Hoke on behalf of the people.
Rachel Wolf, my P number is 79204. I am here on behalf of Brent Michelle.
Okay, we're set here today for a hearing on a resentencing, which resulted primarily, at least to start with, stipulation of parties that CRB3 had been properly scored, and then there were 3 other challenges to the result. Ms. Wolf, I did receive your memorandum that was presented to the court before the previous date, which was scheduled for May. So I had a chance to review that. I did have a chance to review the prosecutor's submissions along with a victims impact statement that was submitted by people. a chance to review all that prior to today's hearing. I do want to address any further argument on the defense variable issues, so we want to start with OB9. Ms. Wolf, was there anything that you wanted to add today by way of oral arguments to that?
Sure, Judge. I just want to note first, and maybe we'll get to this a little bit later on, but I do have a copy of the updated pre-sentence investigation report, and I've had an opportunity to go over that with my client. I have a couple things to note about the PSI. We can do that after the offense variables.
Yeah, so my thought was once we resolve the variable challenges, then we'll go into the normal sentencing procedure, address any other issues.
Well,
I know there are some corrections such as jail credit for sure that based on the delay of a month. So,
right. So with respect to OB9, I mean, I think that I briefed it extensively as far as providing this court with the relevant case law. I am going first, but unfortunately, I am not sure how the prosecutor intends to proceed. I know in the response brief that was filed, there was an indication that we might have the presentation of further testimony today. I want to start by saying that I do object to the presentation of further testimony, but that is not to be combative, so I want to explain it. At this point, we've had one sentencing hearing and the preparation of PSI there. I had the motion to correct invalid sentence and the response time. We had a hearing on that. We've had the prosecutor's response, another updated PSI. And at this point, I have no objection. I received the prosecutor's response and all the attachments, as well as the amended victim impact statement. I have no objection at all to the court considering those materials and any of the allegations that are made in those materials. I think the presentation of testimony on the same matters would be cumulative. And anything in addition to those matters, I think would be an unfair surprise, because at this point, I have no information at all to suggest that there are more facts on the record, what they might be, how I could possibly investigate, respond, but new allegations. And so I just think it's unnecessary. I did want to note that I did attempt to reach out to the prosecutor's office. We spoke over the phone and my email in an attempt to make sure that Mary did not have to take the stand today and testify. We could resolve those issues in advance. So if there is anything that's not already on the record, I think it's an unfair surprise to me to put that on at this point. With the evidence that is on the record, even with all of the text messages attached to the response, there was no updates to the agent's description of the offense in the PSI that I noticed. So we're working with the exact same factual record that we had at the motion hearing, with the addition of the text messages and the impact statement. And I still, based on the case law that I have and that I presented to the court, I don't see any allegations that support a close proximity to actual physical harm for Mary, but I think even more clearly for the second alleged victim. Of course, this has to be two people that were in close proximity to a physical harm, and as I stated in my brief, that's things like being present during an armed robbery and having a gun or a knife swung or pointed at you. There's the one case where it's a reckless driving and the car swerves across the road and almost hits a school bus. Like, those are close proximity. You could be imminently physically in danger. And I don't see, at least rising out of the sentencing offense in this case, which is all we can consider for OB9, any facts that support scoring 10 points. So I do object to any score. OB9 should be scored at 0.
All right, thank you. Ms. Koch, how do you want to proceed today?
I spoke to Mary, who's present today in the courtroom, and she wrote this letter, and I think it added all of the things I intended to add. I don't ask to take any additional testimony, and she's not going to ask to read her letter because the court already has it. I confirmed with the clerk. So I don't have any additional information. There is some information in there that I think was important to the court, because normally we have the PPO and then we have the violations. And in this case, they were handled in 2 different counties. So some of those facts that started this case, which you have to have a PPO in place in order to get to aggravated stalking, which is what we got here, I think are very important. She's talking about the knife incident, and that PPO is part of this charge. I mean, it's that you're violating a PPO. All the facts that led to that PPO, I think are part of that continuing event that led to aggravated stalking. Aggravated stalking is one of the weird charges that doesn't involve just one instance. It's accumulation of instances. And in this case, lots of them. And I briefed that, and I think the court's already read the brief. I don't have anything further to add.
I just have one thing, if I could just briefly. I read through the victim impact statement very carefully as well. I do respect that was filed and appreciate it as well. But so there is an incident here involving a knife where he, showed up at the house allegedly, and this situation led to the filing of the PPO. This is very clear from the impact statement that that incident happened before the PPO was even ever put in place. When we're looking at OV9, we have to look at the circumstances underlying this particular offense. So those fall outside of the sentencing offense. That's all that I would add.
Okay. All right. So the court did have a chance, of course, as I've indicated already, to review all the submissions to the parties. The court has to find that any offense variables are supported by facts constituting a preponderance of the evidence. The court can rely on information contained within the PSI, police reports, victim impact statements, and any types of sworn testimony that are taken in finding facts as to whether or not that burden of proof has been met. In this case, we're dealing first with OB9, which is currently scored at 10 points. OB9 involves injury or potential injury to victims. At 10 points, it's 2 to 9. Victims placed in danger of physical injury, and that's what we're talking about in this case. As both sides have correctly pointed out, the court has to look to the sentencing offense and not to external conduct outside of the sentencing offense, and it has to be conduct that is relating to the sentencing offense. And so, I agree with Ms. Cope that we have to look at what is the offense here. It's aggravated stalking. How do you get to aggravated stalking? One of the ways is by violating the personal protection order. How do you get a personal protection order? You have to engage in willful force of conduct that meets one of the criteria under the statute. And what is that? Stalking means a willful force of conduct involving repeated or continuing harassment of another individual that would cause a reasonable person to feel terrorized, frightened, intimidated, threatened, harassed, or molested, and actually causes the victim to feel that way. How is course of conduct defined? A pattern of conduct opposed with a series of 2 or more separate, non-continuous acts while evidencing the continuity of purpose. So this isn't the type of crime that occurs in a vacuum. It's not one incident that's isolated. So when we're looking at conduct relating to the sentencing offense, in the context of aggravated stalking, I think the court can look to a much broader set of facts than it could in a typical criminal situation. I think the court can look at all of those things that constitute the course of conduct, the pattern of conduct of 2 or more separate non-continuous acts. And the definition of stalking, a willful course of conduct involving repeated or continuing harassment. So I think the whole statutory scheme involving aggravated stalking contemplates that this is more than just one incident. It's numerous incidents, separate non-continuous acts that all evidence a continuity of purpose. So in my view, interpreting that as it applies to OB9 relating to the sentencing offense, as long as there are acts that evidence that continuity of purpose or willful course of conduct directed at Ms. Michelle's, then that is all going to be conduct that relates to the sentencing offense. And in this case, the court finds that there is a preponderance of evidence to support that Mr. Michelle's did put 2 or more people in danger of physical injury during several of these separate non-continuous acts, which I think clearly evidence a continuity of purpose here. His purpose in threatening, harassing, frightening, intimidating Ms. Michelle's. And Ms. Wolf pointed out one of the incidents that the primary incident that the court is basing its ruling on OB9 here. That is the incident involving the knife where Mr. Michelle's, in my view, in that incident, threatened to kill Miss Michelle's, threatened to kill himself, threatened to make individuals present, which included Miss Michelle's and her niece, watch him kill himself, breaking windows. So Miss Michelle's, her son, her niece were all present during that incident. And in my view, that clearly, under a preponderance standard, his actions during that incident put all three of them at risk of physical injury. So the court finds that OB9 is supported by preponderance of the evidence, and that even though that was prior to the PPO, that incident was part of the separate non-continuous acts engaged in by Mr. Michelle's, evidencing his continuity of purpose, which again was to threaten, harass, frighten, intimidate Ms. Michelle's. So the court finds that it is part of his course of conduct in engaging in aggravated stalking, and therefore it is related to the sentencing offense, such that the scoring of OB9 is appropriate. So for those reasons, the court will deny the challenge. Moving on to OB10, any argument other than what you've already presented on that?
Yeah, with respect to OB10, that's the predatory conduct, I believe. That's thoroughly briefed. I don't have anything to add at this time.
So,
And I'd just point the court to the victim's statement that we submitted. And I think we get to a point where she ends up having to file a PPO, but as you can see, all the things that led up to that, including monitoring every phone call, monitoring every movement, putting up cameras inside, outside, alarms. I mean, all of that is predatory. I think of all of the challenges, this is definitely our strongest. I think everything about this case shows predatory conduct. Thank you.
anything in response? Okay. Again, applying a preponderance standard to OB10, which was scored at 15 points for predatory conduct. The court has to first find that there is some type of vulnerability, can relate to a domestic relationship, which I think obviously is the one that applies in this case. The court has to find that the defendant manipulated that relationship for what case law is defined as selfish or unethical purposes to rise to the level of predatory conduct. It has to be conduct that's not merely opportunistic. In other words, it just doesn't present itself to the defendant. It has to be an element of lying in wait, and some of the cases actually use the word stalking as part of the definition of predatory conduct. OB10, it has to be predatory in nature. It has to be directed at a person for the primary purpose of causing that person to suffer an injurious action, either at the time or eventually. In this case, again, relying on the victim's statement that was submitted, I actually started going through that to highlight particular portions of that that I thought qualified as predatory conduct, and I ended up highlighting so much of it that I'm simply going to adopt the entire statement as a basis for a finding that there is, by preponderance of the evidence, more than sufficient proof that Mr. Michelle's was engaging in predatory conduct. He was clearly manipulating Ms. Michelle's vulnerability based on that domestic relationship, the fact that they shared a child. And he was certainly engaging in lots of conduct that could be considered lying in wait or stalking, certainly predatory in nature. And again, rather than try to pick out individual portions of that statement, the court finds that almost the entire statement, descriptions of Mr. Michelle's actions, show predatory conduct. So for those reasons, the court will deny the challenge to OB10. Final one is to OB13, and that follows the pattern of felonious acts, 3 or more directed at a person in 5 years. As well as your argument to the extent it's more or different than that.
Thank you, Judge. I actually didn't prepare very much for OB 13 today because I thought that it had been very well briefed. I think the real heart of the argument comes down to whether or not separate acts underlying and making up the aggravated stalking offense itself can constitute separate felonious acts, each violation of the PPO, which of course I argue is not a separate felony. But if they are, they support, additional aggravated stalking counts potentially. We could look at those as separate offenses for purposes of OB 13. But I will say, and I don't want to misquote the court, but in discussing OB 9, I believe more accurately described aggravated stalking as a whole offense which contemplates numerous separate non-continuous acts. And I think that if that logic applies for OB 9, I'm not sure why it would not also apply to OB 13. So in order to create a pattern of 3 separate felonious acts against a person, aggravated stalking should count as one, and all of the acts that make that aggravated stalking offense should also count as one. And then there are not, unless I'm reading something wrong, 2 other felonious acts against a person here that would count to score.
Thank you. Ms. Coe.
I respectfully disagree with counsel. We kind of discussed this. I briefed all of the issues that I thought were separate. I don't think because you pled to the one charge that involves all of them, that you essentially get a free pass, and each of those don't count as a separate offense. Each of them that rose to a felonious level, not all of them do. I mean, if you hang up a camera, that itself probably wouldn't be enough until you have more actions. It is the cumulative nature of all of these that led to this, but there are, as I pointed out, at least 2 felonious assaults. There was the dissemination of the pictures. And then I thought about what happens after you get charged with stalking. If you continue aggravated stalking, if you continue to stalk them, does it all count as one? Do you get a free pass to continue to stalk that person forever? And I think the answer is no, because even after he was charged, even after he was arrested, he continued trying to contact her even from jail. And the court sees all that. So I think it's briefed and I don't have anything else to add. Thank you.
The only other thing I would say that I believe that the prosecutor has the discretion in the way that they structure the charges and as far as what's going to count as an aggravated stalking in a separate aggravated stalking in that case.
Thank you. I did have a chance to review OB 13, and there are essentially 3 different requirements that the court has to find for each incident that's claimed as a separate felonious act that would qualify for scoring. The court has to find by the preponderance of the evidence that more likely than not that conduct, whether it has resulted in a conviction or not, or has to find that it's a crime against a person and that it occurred 5 years of offense. In this case, number 1, looking at the dismissed charges in a crime, the 2-year to 4-year charge that's listed as a variable. That's clearly a felony. I think, given the information within the PSI and the victim's statement, I think there's more than preponderance of the evidence to show that the defendant is actually guilty of that crime. Dismissed for the plea agreement. It's listed as variable under the statute as to whether or not it's a crime directed at a person, because it depends on the underlying circumstances of that offense. In this case, the court finds that the computer crimes were crimes directed at a person because they used victimized shells. So the court finds that those felonies would be countable as contemporaneous felonious acts. In terms of the other actions of Mr. Michelle's, the court finds that, again, the knife incident in and of itself could qualify as a felonious assault. Again, the court finds that there's more than preponderance of the evidence to support finding that Mr. Michelle's been engaged in that conduct that was directed at Ms. Michelle's, the niece and their son, as well as other acts by Mr. Michelle's during this course of conduct, including, I think, additional counts that could have been charged for violating the PDO. And I think there is a distinction between finding that the court can rely on issuance of person protection order actions by Mr. Michelle's for finding points under OB9 and separate incidents that could have resulted in felonious charges under OB13. I think there is a distinction there because a person could be convicted of multiple counts. In this case, resulting from the violation of the same PDO, and it doesn't invalidate the actions that led to the PDO in the first place, or make them or separate them from the issuance of the PDO versus, really not explaining this real well, but the fact that separate felonious charges could result from violation of the same PDO, even though the underlying conduct that led to the PDO itself is the same. So the court finds there's a distinction there, and it doesn't prevent the court from finding under OB13 that there were separate felonious criminal acts. So the court finds that there are at least 3 and likely many more than 3 felonious acts that would qualify for scoring under OB13. So the court will deny that challenge as well. Do you have any other challenges as well to the scoring?
Not to the scoring, Judge.
Then as to the corrections in the PSI, as I indicated, I believe the direct conduct cell credit at this point would be 832 days.
Yes, Your Honor.
Yes, Judge. I counted 833, but I counted today, and I didn't know if that was correct.
No, we usually don't count. Are there any other additions, deletions, or corrections?
Just the date needs to be changed to June 6th.
Okay.
And I do have some brief objections to the content of the report.
Okay. Are they corrections, or is that something that should be addressed?
They're corrections.
Okay.
So the first one is that I do object, always object, to the probation agent's discussion of the proper scoring of the guidelines inside the PSI. I don't think it's appropriate for that to be in there. Obviously, it is on the court to score the guidelines and to render the sentence. And so I know a lot of probation agents do it. I don't think it's appropriate, so I just object there and ask that they be stricken. And the other thing that I wanted to mention is that my client did not have an additional interview before the amended pre-sentence investigation report. And I didn't know that until last week, so we're not asking for an opportunity for an interview at this point, but I would ask that in lieu of that interview, the court would allow attachment of my resentencing memorandum to the pre-sentence investigation report for the parole board to consider as well.
Okay. I don't have any objection to that. So the court will grant the request to attach that to the PSI. In terms of the agent's rundown of the scoring, I don't find that that's objectionable. It's noted for the record, but the court is not going to remove that from PSI.
Thank you.
Any other additions, deletions, or corrections? Ms. Cope, do the people have any additions, deletions, or corrections?
No, Your Honor.
You have, does Ms. Michelle wish to take the statement here today?
She does not.
Allocation.
And I said this at sentencing. I'm familiar with both the parties. They both come from really good families. I'm not surprised to see both sides have their families present today in the courtroom. This was a really terrible circumstance. I thought the recommendation was fair when the court did it. And I think it's fair today. I'd ask the court to just continue the sentence. Thank you.
Thank you. Ms. Wolf, anything on behalf of Mr. Michelle's?
Yes, Judge. So the first thing that I would note is I made an error in my resentencing memorandum that I wanted to correct on the record. I did refer to the fact that his sentence guidelines were the same, whether he accepted the plea or not. And I believe I might have been looking at the amended felony information when I said that it was second half regardless. That's not true. The prosecutor did reduce the habitual fourth offender to a second. And so there was some benefit there for Mr. Michelle in taking that plea. I just want to clarify and not mislead the court, obviously. So there's a couple other things I want to say in general. As the court knows, and I know that you know, Your Honor, we're not here because of Mr. Michel's failure to accept responsibility. We are here because all of the people involved in making sure that justice is appropriately meted out and the law is followed. The prosecutor, Your Honor, myself, all of us, we want to make sure that things are correct and people make mistakes. So the appellate process in the state of Michigan is a really, really good thing. It acknowledges human error, and we would not be here if there were not mistakes. I would have brought a motion, Your Honor, we granted a resentencing. And I just wanted to make that clear on the record. I'm not diminishing Mary's experiences or disputing today any of the circumstances that she's described in the victim impact statement. I also am a woman. I can identify with the position, and I truly, you know, we both can empathize with the situation. And so what happened. And I can only speak to my experience with Mr. Michel since I've represented him. It's been several months. All of the evidence that I have in all of my interactions with Mr. Michel suggests that he has taken responsibility for what he's done. I know that there's still a little bit of residual frustration with how things have worked out. And, you know, he does have to spend nearly, well, depending on what happens today, he spent nearly 4 years of his life in prison. So it's fair for him to be a little bit upset about that particular part of this. But as far as, you know, talking about this case, he accepted the plea. He has not, with me, focused on disputing any of the facts. He's expressed to me embarrassment and remorse. He has expressed that he appreciates this opportunity for separation from the town, from the incident, from his substance issues that clearly, I think, led to the offenses in this case. So from what I've seen, there has been an acceptance of responsibility. I know the character letters that I attached also suggest the same thing. So as far as the appropriate sentence, I just want to point out, I addressed this in my memo, but the sentence guidelines largely account for the severity of the conduct. Mr. Michel had no prior incidents of violence before his life kind of went crazy. And he developed a substance abuse issue, which again, I think led to all of the rest of this. And he's taken significant steps to address the substance abuse issue. So he has a nearly clean MDOC misconduct history. I do want to briefly address the substance abuse violation, which happened, I think, over a year ago now, and not to diminish it. But there are two people in the shared space. One of them, Mr. Michel's bunkmate, did have a significant amount of, I don't even remember what he had under the bunk. It was a shared space. So it could have, either one of them could have been responsible in the situation, but I would note that the MDOC, to punish him, only gave him 10 days loss of privileges, kept him at the same, Mr. Michel kept him at the same security risk and let him keep his job. And I think that that is reflective of how seriously the MDOC took the violation and how culpable they thought Mr. Michel was at the time. So I wanted to make sure the court knew that. Other than that, Mr. Michel's completed batterers intervention, he's done a resume workshop, voluntarily attending substance abuse classes. Right now, he does one NA class and one 12-step class every week, and he is not looking to resume any substance abuse issues in the future. I think this has really shocked him. He's still working with the yard crew, low security risk. And I think most importantly, throughout his time in the MDOC already, he's had no contact or attempted contact with Mary. There's been no letters, at least unless there's something I don't know, no letters, no phone calls, nothing. And in fact, Mr. Michel has even respected his son's desire to not have contact with him. It has not even reached out with to his son, even though that's been particularly devastating, I think, for Mr. Michel. this behavior clearly arose from that substance abuse issue, and he's not gonna go back to it, as far as I can tell. He has tons of potential. He's had really good jobs, Moser Mechanical and Cape Fear Engineering and several others. He's got lots of community and family support. His father is here today. And so essentially, Mr. Michelle just wants to be the person that he was before this happened. And I think that in this case, especially, there is a lot of evidence that that's exactly what he can do. So we would just ask that the court consider a lower sentence in this case. Leave it at that.
All right, thank you. Mr. Michelle, is anything you wanted to say today?
No, sir, I think that's well covered.
All right, again, I thoroughly reviewed all the documentation relating to this case, in preparation for the resentencing hearing today. And so I'm fully familiar with all the facts and circumstances, and, frankly, this really isn't, nothing about what we've discussed today has changed the court's view on what an appropriate sentence is in this case. I completely agree with Ms. Wolf that the appellate process is important to the system. It is important that things are accurately scored according to the law. So to the extent that there are questions about that have arguable merit, which I think these challenges did, then it's important for the system and the court and the attorneys to address those, to get rulings on those, to ensure that things are done correctly. And I think that's what, to me, this process was about today. The court took each of those challenges seriously, did a lot of research on those, looked at the facts to arrive at the right decisions. And if they're incorrect, then the appellate court will tell us that. We'll go further with it, and if not, we won't. But to me, this was more about that process than it was about taking another look at your circumstances, because again, while those things might have affected the guidelines, they didn't affect what I think is an appropriate sentence based on your conduct. And I think that, through your conduct, you've earned every day and every week and every month of the time that you're going to serve. And everybody may have their opinions about you, family, friends, employers, attorneys, but nobody has had the same experience with you that Ms. Michelle's had, and nobody has seen the side of you that she's seen. And so I don't think anybody is in a position to compare their experiences with you as to what a sentence should be in this case. The court should look at what her experience was with you, and I'm satisfied based on everything that I've seen that it was horrific, and that nobody deserved to go through what she went through with you. And I completely understand when she says that the only time she's really going to feel safe is when you're in prison and not available, because I think realistically, as a practical matter, anybody who's been through what she's been through would be worried outside of that circumstance. For all those reasons, the court finds that the initial sentence that it imposed was appropriate, and the court will continue that sentence. That is 47 months to 7 years, 6 months. Corrections. As indicated, you do have credit of 832 days served. The court will preserve all the fines and costs that were imposed at the time of sentencing. You have the right to appeal the sentence, of course, and this will be able to have Mr. Michelle's acknowledge.
Yes, Judge. Thank you, Judge. My client has received the appellate rights in this initial form here.
No, thank you, Your Honor.
Interesting.
Hearing concludes the court's morning. The court will be in recess until